Mr. Mills, my lady. I just had one point to finish up on the respondent's notice points, which is paragraph 47 of my learned friend's skeleton. And the argument here is that any conversion could not have been to Mr. Conway's use because Mr. Conway indirectly held 47.68% of the shares in Lodgeshine, and it's suggested over the page that is insufficient because Mr. Conway was not the majority owner stroke controller of Lodgeshine, and that is said to be, I take the C burden at 37 and 22 to mean to suggest that is a requirement. Our short answer to this is that simply isn't a requirement. There is no need for a conversion to be to the director's own use, that they must have a majority interest in the company through which the conversion takes place. Ultimately, we suggest this is simply a factual question as to whether or not the property has, in substance, come into the use of the relevant director. And I take that both from the wording and the purpose of section 21(1)(b). In terms of the wording, it simply refers to the property being converted to the trustee's own use. Now, there may be many ways in which property can come into the use of a person. An example may well be where they hold a majority interest and could therefore appoint directors to the company and ultimately can control it in that way. But that is not what the section says. It simply says it comes into the director's own use, and it's, I think, should be uncontroversial that there are plenty of ways that a person can have control of a company without a majority shareholding. There may be a shareholders agreement, they may be the sole director, there is no magic in a majority interest, and indeed there may be other structures. For example, the discretionary trust seen in the Haysport case, where actually there's no shareholding interest, but there is an interest under a discretionary trust and an ability to influence the trustee in practice, and the court may be able to say that the property has thereby come into the use of the relevant person. Equally, when one turns to the purpose of section 21, the section, as we know, is concerned with stopping people getting the benefit of or retaining the benefit of the trust property. There's no reason why that section should not be engaged where it is a 49.99% interest, but would be engaged if it was a 50.01% interest. In both circumstances, the evil at which the section is aimed, directors being able to retain, trustees being able to retain benefits of trust property, are engaged. So why is it then suggested that there needs to be a majority interest? Well, the only reference given is to Burnden, and I'm going to go to the Supreme Court. So that's in Authorities Bundle 4, 45, page paragraph 22, that's page 1243. And paragraph 22 is simply applying the principles to the facts of that particular case, in the present case, and then explains why those requirements are satisfied on that case. And indeed, in that case, the two directors, the Fieldings, were between them the majority owners. But when one looks at the middle part of that paragraph, it was a conversion of the shareholding to their own use because of the economic benefit which they stood to derive from being the majority shareholders in the company. The Supreme Court is not saying there needs to be a majority interest. They are simply saying that it was on the facts of this case to the director's own use because they stood to make an economic benefit in their capacity as majority shareholders. And indeed, it's perhaps interesting in that context just to look back at the facts. You would just go back to paragraph 5 on page 1238. see about 3 lines down, the paragraph 5, near letter F, the issued share capital of the claimant comprised 3 classes, 50,000 A, 50,000 B, 50,000 D. The A and B ordinary shares were held by Mr. and Mrs. Fielding in equal parts. And then at paragraph 7A, they get the same shareholdings. The shareholders of the claimant exchange their shares for a new holding company, BHUH, which is one of the vehicles through which the distribution was made. It was, in fact, the recipient of the unlawful distribution, the immediate recipient. Now, it is therefore true that between them, Mr. and Mrs. Fielding held a majority interest, because between them they held 100 of the 150,000 shares. But each of them individually, because they held shares in equal parts, held a minority interest of 50,000 shares each. But there is absolutely nothing in the Supreme Court's judgment to suggest that the claim would be time barred if it succeeded against only one of the Fieldings, because it had to be a majority interest, and so the claim could only succeed if both Mr. and Mrs. Fielding were both found to be liable. And so we say there is simply nothing in Burnden to support the proposition that use can only be achieved through a majority interest. As we say, inconsistent with the words, inconsistent with the purpose, and not supported by authority. The real question here is, did Mr. Conway get use of the annex? And on that, the position is really beyond doubt. Mr. Conway admitted in the defence that he had control of Galliard Homes, which is the 100% parent company of Lodgeshine. I'll just show you that. That's core bundle, tab 11, page 231.
Just get this right in my notes. Which paragraph are we in?
I hope you weren't going to ask that.
17, it looks like.
It is 17 F Roman 1 of the defence.
Yeah.
And so you can see that it is averred that Lodgeshine and Southbank were wholly owned subsidiary of Galliard Homes, which Mr. Conway controlled through his shareholding in Galliard Holdings. So it is positively averred that he controlled those companies. And indeed, his own evidence, which is quoted in the judgment back at tab 6, page 96, there is a paragraph 176. There is a quote from Mr. Conway's third witness statement, where he is explaining the control he had over the entire Galliard group. But you'll see towards the end of that, he says, I caused Galliard Hotels, Lodgeshine and Southbank to enter into the lease and underlease. So there is no doubt that the reality of the position is that Mr. Conway controlled Lodgeshine, and therefore, indeed he was its sole director, and therefore an asset in the hands of Lodgeshine was one of which he had use because he was able to control it, and indeed he would benefit personally as to nearly 48%, with his family receiving the remainder of the economic benefit. And to say that a situation where a man has control of a company and will receive 48% of the economic benefit is not sufficient to trigger Section 21 would, in our submission, be flatly inconsistent with the purpose of Section 21. Why should he be able to control the benefit of a trust, formerly trust interest for himself and for his own personal benefit in very large part? So we suggest nothing in the respondent's notice.
Can I just ask you about paragraph 346?
Of course. Yes. Yes. This is dealing with a slightly different question. This is where we were putting the case in a slightly different way, which was to say it was actually in his possession. And so you can see that it said, second line, the lease should be treated as being in his possession, albeit through a corporate wrapper. And for that purpose, we would need to pierce the veil. That is to say that something which the company possesses is in the possession of its shareholder would require a piercing of the veil. One of the reasons the judge gives as to not being willing to treat a company asset as being in the possession of Mr. Conway is that he did not have control of the majority of the shares. And I don't seek to go behind that, but that doesn't detract from the conversion to own use question, which is a rather different one. And you see, just to make good the piercing the veil point, 347, in addressing this question of possession, he explains that would require a piercing of the veil, so the director is treated as possessing the property held by the company. And so it's, if I can put it this way, focusing on a different question, much as in Re Burnden, the property wasn't possible to pierce the veil and treat the property as being in the possession of the Fieldings, but they were nonetheless regarded as having the use of it. The use, in my submission, being a much broader concept to be read purposefully.
Just going off on a brief tangent,
Yes.
I haven't got clearly in my mind how the boards work. So with Lodgeshine, Mr. Conway was the sole director.
Yes.
With South Bank
Sole director.
and with Galliard
Hotels, sole director. I'll check that. I think sole director. The where there is a board of 4 people is in Galliard Homes. I think I've got that right. Galliard Homes, which is the parent company above Lodgeshine and South Bank.
So the lease is granted by a company which has 4 directors.
No, the lease is granted by a company of which he's sole director to a company of which he's sole director.
Oh, I see. Yes,
and
it's
back
home
to the
hotels, not homes.
Yes.
Yes,
And the way that the Board of Homes comes into it is that there's a ratification argument.
yes.
That it said that Homes has ratified any breaches within South Bank and Lodgeshine,
Yes.
and indeed hotels.
And the passage you just took us to in the judgment,
Yes.
that was to do with homes when it referred, because I think that's the one where it referred to the other directors. So, sorry, that was paragraph.
So I'm just checking which paragraph I in fact took you to.
sorry, that was-
Paragraph 176. Yes, that's talking about Homes. So paragraph 176 is because it's dealing with ratification. It's saying that the Board of Homes can effectively be disregarded because they just did what I told them to do.
Yep.
Or I think even more than that. Actually, I didn't tell them anything and they didn't care. But so, in terms of what happens, if we are right that our claim is not time barred, we suggest that the proper course is for a remission for the judge to make findings of breach, ratification and excusal. The reason we suggest that is although the judge says he has made factual findings, as indeed he has, We are concerned that it is always difficult for an appellate court to reach what are effectively first instance decisions, looking only at a handful of findings and without the full feel for actually the evidence behind that, the documents, the totality of the transcripts. And the reality is a bit like a reasons appeal. There's a bit of a danger of island hopping, which is you look at findings, but you don't have the full picture. And it therefore seemed to us that remission would be the most appropriate approach.
And that's breach, ratification and...
Excusal under section 1157, so that he's behaved honestly and reasonably and it's fair in all the circumstances to excuse any breach.
Thank you.
In that context, what I propose to do is just tell you briefly why we say there is at least an arguable case of breach on the judge's findings. We do say that if necessary, you could in fact conclude in our favour, but I think I'm realistic enough to accept that that is he's asking a lot of an appellate court to make dispositive factual findings, but evaluative findings. We say, as in terms of breach, we say that there is clearly, and we say unarguably in our favour, but certainly there is an arguable case of a breach of the duty to avoid conflicts. The question whether there is a conflict of interests is simply whether there was a real sensible possibility of conflict. That is Boardman and Phipps. It is an objective test. What would a reasonable person consider there to be a real sensible possibility of conflict? We say as soon as Mr. Conway came up with the idea of revisiting or amending the transaction structure to rentalise the annex, there was obviously a real sensible possibility of conflict between South Bank and Lodgeshine. On the judge's findings, Mr. Conway knew that if he didn't act, South Bank was going to receive the annex under its existing contractual rights. He also knew that that would ultimately benefit the investors and not him. If, however, he were to enter into the Annex Lease Scheme, he and his family would get a significant financial benefit. So his interests, personal interests, were directly opposed to South Bank's interests. And that conflict exists whether or not Mr. Conway believed that in some high-level sense something had gone wrong with the structure that he wanted to put right. And we say the obvious problem with what happened here, we don't need to go this far for a breach of the duty to avoid conflicts, is that from the outset, Mr. Conway approached this on the basis that he wanted to rentalise the annex if he could. He wanted to correct what he perceived to be an unfairness to him and his family. But that is not the way an unconflicted director, wholly uninfluenced by personal interests, would have acted. That person would have looked at South Bank's interests with a single-minded loyalty. He or she would have said, well, we have a vested legal right worth millions of pounds to this annex. Do we want to give it up? Obviously, it's not contrary to our interests to do so. And one would expect the independent director in that situation to look at whether there was a legal obligation to give it up. Could the contract be ratified? Because if there was no legal basis for giving it up, the company could quite properly stand on its rights and say, well, may not have reflected what you at some high level sense intended, but that's what we've got. There's no basis for us to give it up, and therefore it's not in our interests to do so. We get nothing out of giving up these rights. But that's just not the way Mr. Conway approached it, because he was hopelessly conflicted. And one can imagine the sense that comes over from the judgment is that Mr. Conway is a hard-nosed business person. If Galliard Hotel had been an arm's length developer and it had come and said, look, not legally, but we didn't really mean to do things in this way. Can we just put it all right? You give up millions of pounds worth. I imagine Mr. Conway would have turned around and laughed at them. He'd have said, sorry, that's business for you. You get your contract right, or you lose out. And unless my lawyer tells me I've got to give this up, because otherwise you'll bring a rectification claim, I'm keeping my millions, thank you very much. But the problem is he was hopelessly conflicted. Now, the only answer to this that I am able to discern...
Just before you get to the answer, what's the remedy?
Damages.
For what? He's in a position of conflict, you say.
Yes.
Now that might bring into play the no conflict rule, where you have to account for profits.
Well, it could give right to an elect between an account of profits or equitable compensation.
Well, that might be a different proposition. So, can we take the first? So, classically, the no conflict rule can give rise to a duty to account for profits. The profits would go back to the 47 or whatever percent, would they?
Well, we have not put it as that we would seek an account of profits.
But you can't get more by, can you? Where does the obligation to pay compensation derive from?
Simply because it is a breach of an equitable duty, which gives rise to an entitlement either to equitable compensation to put a party in the position it would have been in had that duty been complied with, or an account of profits.
I mean, as you say, you're already trying to show arguability, but I'm not sure the authorities are playing in your favour on that. I mean, no conflict rule potentially gives you an account of profits. The possibility of conflict potentially imports the self-dealing rule or the fair dealing rule such that you can have rescission, but rescission isn't in play.
Yes.
If you want compensation for loss, that sounds more like asserting a positive breach of duty. And I don't think the no conflict rule is a positive duty of that kind, is it?
Well, my submission it is, but I think I'd probably have to come back to you with an authority to make that good.
I mean, there could be something slightly different, which would be you alleging breach of the duty of loyalty, breach in failing to act in the best interests of South Bank.
Yes.
But that's a different thing.
Yes.
Then there'd be a debate over how far that implied a duty to act as opposed to a duty not to act. And in any event, the duty to act might be constrained by what you thought was in the best interests of South Bank, and that requires a different analysis.
Yes.
And what's actually pleaded?
What is pleaded is a claim for equitable compensation.
For what?
For breach of all of the fiduciary duties, including duty to act in best interests and to avoid conflicts.
Okay, could we just see that so I understand what is being
Yes. claimed? So the re-amended particular claimant core bundle tab 10. And the allegations of breach are paragraph 33 on page 192. And so paragraph 33.1 is what happened, and then 33.2 you get the allegation of preferring interests and therefore acting contrary to best interests.
Sorry,
33.2.1 alleges preferred the interests of Lodgeshine.
so this is an allegation of failed to take action. So that implies that you're alleging that there was a duty to take action, does it?
Sorry, I'm not. Where are you? The words failed to take action.
The failure to take action against Galliard Hotels preferred the interest of Galliard Hotels.
Sorry, I'm looking at 33.2.1 on page 193. Both the lease and the underlease preferred.
And the failure to take action
Yes.
preferred the
So
interest.
33.1, just going back a page, alleges that Mr. Conway caused or permitted, as sole director of Lodgeshine and SBHMC and a director of Galliard Hotels the lease and underlease. And at 33.13, South Bank to enter into the Annex Lease Scheme. So that's an allegation of cause or permit.
Okay, pause there. So why is that causing or permitting said to be wrong?
Well, it's said to be in breach of the foregoing fiduciary duties, which are set out at the top of paragraph 30. So they are proper purpose, good faith.
So which one or all of them?
Well, and that's then what 33.2 does.
Well, that says further.
Yes, and I think on a fair reading of it, 33.1 is setting out what happened,
Okay.
and 33.2 is setting out why that is wrongful. And 33.2.1 says that the lease and underlease preferred the interests, and separately, the failure to take action against Galliard Hotels preferred the interests of Galliard Hotels, but the lease and the underlease preferred the interests. Further, hopelessly conflicted. In each case, preferred own interests, and in each case, acted contrary to the best interests of South Bank. So that is a pleading both of conflict and failure to act in the best interests of South Bank. And then,
33.2.3 we can ignore because that's failure to exercise care. Is it?
save for the last 10 words, which allege conflict again, but they're not. That's not adding very much.
Permitted situations to arise.
Yes.
But it's also isn't that the improper purpose as well,
Yes,
which is a separate
the
fiduciary?
separate point. Yes.
So it seems to have rolled up there the duty of care and some fiduciary duties.
I'm in a slightly invidious position. It's not my.
I know.
Sorry, I
I
didn't
know.
mean that. They're all in the same.
And 33.2.1 similarly rolls up conflict and best interests. And it might be said it rolls up actual conflict, i.e. positively preferring, with potential conflict, which ought to be avoided in the first place.
I'm a bit worried by this because, at least in my own mind, they give rise to different consequences. If you act contrary to what you believe the interests of your principal are, that brings about certain consequences. Arguably, if you fail to act in what you see as your principal's interests, that brings about certain consequences. I'm not sure the consequences are the same if you are merely in a position where you have a duty, have a conflict.
Look, can I answer that in two stages? Firstly, say I will come back to you. I think, I fear this is a dangerous stand to take, but I think the authorities do support that you can get damages for acting where you are in a conflicted situation, even without proving positive preference. Now, there may be a separate causation issue as to whether you can show that something different would have happened if that person had removed themselves, but I think my submission certainly will be you can. But I think my second and perhaps more fundamental point is that you don't need to worry about this, because all you need to conclude is that either there is an arguable or there is a breach. The question of remedy would be, I think on any view we all accept, would have to go back down, and whether we could only seek an account of profits and therefore everything that flows to the 47% shareholder would be a question for the first instance judge.
And just thinking that through for one moment, I mean, you'll send me authorities tomorrow to explain that I've got all this wrong, but certainly traditionally the no conflict principle entitles you potentially to an account of profits, and you say there was a conflict. Does the pleading allow you at least to claim that?
It does, doesn't it? Under the prayer, Act 2, as against Mr Conway,
Yes.
A, liable to account.
Yes,
Am I in the right place?
you are.
Thank you. That's on page 202.
Sorry, so
Paragraph 34 as well, possibly.
And 34 similarly rolls
Which is
up
the substantive.
liability to account or to compensate in equity.
yes, I see.
But yes,
And
certainly
in
within.
terms of the prayers, I have that clearly in my mind
That's
too.
page
Yes, I see.
202.
2A is liable to account.
Yeah.
Okay. Yeah.
As I understand it, the primary answer, well, it said that any breach, any conflict was ratified. I'll come back to that. The other argument that's made my learned friend Skeleton is that we need to show conscious disloyalty. Now, that is wrong so far as conflict of interest is concerned. Obviously, Boardman and Phipps is the absolute classic example of that, because the directors were found to have acted with integrity and complete honesty, was the way it was put. But nonetheless, they got a personal benefit, and therefore they had to were in breach of duty. Also, there is I'll give you the rest. I don't think it needs to turn it up, but in a case called Richmond Pharmacology, its authorities 3 tab 37. There is the judge. It's a first instance decision, but the judge specifically finds that there is no need to inquire into the state of mind of the fiduciary when it comes to conflict of interest. That's paragraph 70 to 72 of that authority. So that proposition is simply wrong and can't be an answer to the fact that there is objectively a conflict of interest. So I don't immediately see, and it may well be my fault, what the answer to the conflict of interest breach is aside from ratification. We'd also say there was self-dealing, but it doesn't really matter for the reason my lord gave, which is that really only goes to voidability of the transaction. And you can have a conflict of interest. I mean, self-dealing will inevitably involve a conflict of interest. We don't need to show this is self-dealing. It's enough for us to show there was a conflict of interest. We also say there is at least an arguable, if not established, breach of the duty to act in good faith in Southbank's interests. And I emphasise those last 3 words because this is not a duty to act in good faith in the abstract or at some high-level way. And the judge is finding, therefore, that there was, in some high-level sense, a problem is no answer to this. We say that the proper analysis when you get to this is that the test of good faith is only subjective if there is evidence that the director in fact considered the separate interests of the particular company concerned. And just to show you that, that's in Chartbridge, that's Authorities 1, tab 18. Page 336, Mr Justice Pennyquick. It's been applied on a number of occasions subsequently. But, just below the letter D, sideline passage, Mr Bagnall for the bank contended that it's sufficient that the directors of Casper look to the benefit of the group as a whole. Equally, I reject that contention. Each company in the group is a separate legal entity, and the directors of a particular company are not entitled to sacrifice the interest of that company. This becomes apparent when one thinks about separate creditors, or indeed one thinks about a case where one of the companies has promised to become owned by investors. The proper test, I think, in the absence of actual separate consideration, must be whether an intelligent and honest man in the position of a director of the company concerned could, in the whole of the existing circumstances, have reasonably believed that the transactions were for the benefit of the company. And so the way that has been analysed is to say that unless it can be shown that a director has considered separately the interests of the particular company, the test becomes objective, and one has to ask whether an intelligent and honest man in the position of the director could have concluded that it was in the best interests of the individual company. And of course, and I don't think I need to turn this up, in Bristol and West, that is a consideration to be taken wholly uninfluenced by the interests of anybody else. So Southbank is entitled to a director who is thinking single-mindedly of the interests of South Bank. My Lord Justice Miles looks troubled by.
Well, I'm just thinking about the fact that it's part of a corporate group.
And
It's normally the interests of a company, unless you're looking at creditors' interests, are the interests of its shareholders.
yes. And it may well be, therefore, that even thinking individually about the companies of a subsidiary, its best interests are furthered by supporting the group of which it is a member, because that ultimately supports its shareholders and in turn its shareholders. That, however, is a consideration which does not apply, or at least does not apply readily, where the company, it is known that the company is committed to be transferred to investors, and that the transaction is only going to have an impact on those future shareholders. It was
Because of the
rent-free.
5-year.
It was rent-free during the 5-year period.
And is there authority that in assessing the interests of the company, the director must take into account the interests of future shareholders?
Well, I'd put it slightly differently, which is to say one has to look at the purpose of the company, and the purpose of this company was to act as a vehicle for the investors to obtain the benefit from the development. Now, in a sense, one always has to look at, you can't simply concentrate on the shareholders for the time being, because one's looking at as the Act requires, the long-term interests of the company. And of course, shareholders can change over time. But I wouldn't put it that one needs to look specifically at the interest of a particular future shareholder, but that one has to look at the interests of the company, and the interests of the company are long-term and depend on that company's purpose, and recognise that the company, particularly in a case like this, may not form part of that group in the future.
So you say, if Mr. Conway is not shown to have looked at the individual interests of South Bank, you ask what the reasonable person would have thought ought to be done.
Yes.
And in particular, if and insofar as South Bank can be said to have consented to the composite transaction, or particularly to the lease,
Yes.
the independent director would have said that was not in South Bank's interests.
Yes.
Query whether there's an extra stage, which is whether you could allege that the independent director would have concluded that some particular action needed to be taken beyond merely not consenting, if you see what I mean.
Yes, yes, it may well be that in reality, if you imagine an unconflicted situation and someone from Galliard Hotels had come and said, "Can we do this transaction?" they would have got their lawyers involved pretty quickly to write a letter saying, either undertake you're not going to do that, or you're going to be the subject of an interim injunction pretty quickly. But I don't think I need to go that far for present purposes. I'd just say, just posit, if Mr. Conway had stepped back and said, "Look, I can't deal with this. Obviously, I'm going to make a personal profit out of it, so I've got to step back. I will put in place a genuinely independent director, someone from KPMG, who will decide what I should do." What would that person have done? They'd have gone straight to their lawyers and said, "What am I entitled to under this FSC, and do I have to alter it?" And if they were told, as we now know is the true position, there is no basis for rectifying the contract, they would have said, "No, we stand on our rights," or at the very least, they'd have said, "Maybe we can be bought out for a certain sum of money, we can settle this, but we're not giving it up for nothing." And the only reason, being realistic about this, the only reason Mr. Conway did something different was because the beneficiary of correcting this high-level mistake that he perceived wrongly to have occurred was himself and his family. That's the only reason this has happened. So he certainly wouldn't have been doing that had Galliard Hotels been some multinational developer he was unassociated with. And so we say this is a clear case where there has been a breach of the best interests obligation, and rightly so. I mean, it would be an extraordinary thing if the director could give up vested legal rights to benefit themselves simply because they thought this wasn't quite what they had in mind previously. Ratification, really two reasons why we say there is no prospect of ratification here. Galliard Homes had a board of 4 people, Mr Conway and 3 independent accountants. There is no evidence that the board of Galliard Homes even knew about these transactions, let alone was aware of the circumstances and the breach of duties involved. And a fortiori, there is no evidence that Galliard Homes ever took any decision to approve these transactions. And there can't simply be ratification because Mr Conway acted in circumstances where he was a director of all of the other companies involved without any reference back to Galliard Homes. That simply doesn't involve Galliard Homes deciding to ratify, it involves Galliard Homes not having a role. Second, and in any event, there was no act of ratification. As to the facts...
Sorry, could you, I know this is a very basic point, can you just remind us what the corporate structure was? So,
yes.
Is there a...
So, I'm not sure there's a structure chart, we could perhaps produce one overnight, but most significantly, Galliard Homes is the parent company of Lodgeshine and Southbank.
So they're sister companies?
They're sister companies. And I think above Galliard Homes is Galliard Holdings, but you don't need to concern, if I can put it this way, it doesn't, structure above doesn't matter. And so the act of ratification is said to be that Galliard Homes is capable of approving both actions by Lodgeshine and Southbank. As to the facts, the judge made a finding, which is core bundle tab 6, page 96. Looks like a bad reference. I don't think that's not a good reference. Paragraph 177. Now, the judge actually found that the ratification argument wasn't being pursued because it wasn't mentioned in oral argument. But he goes on, so he says he's not going to determine whether there was ratification, but he will record a factual finding that there was no outward manifestation beyond the silence that Mr Conway describes. So all you have is a situation where Galliard Homes says and does absolutely nothing. As to the law, we referred to a decision in Satyam and Burton. Now, that decision actually positively doesn't decide the point. Should probably just show you it. It's Authorities Bundle 4, tab 49. Page 1454. It's paragraph 45, and I appreciate it may be said that referring you to a decision that doesn't decide the point is not particularly helpful, but what it does do is refer to the fact that there is authority for the proposition that one needs an outward manifestation of consent for the geomatic principle to be engaged, and refers to 2 first instance authorities, Renew, CDOS Engineering, where, as Justice Oliver said, he found it difficult to believe that the lonely soliloquies of a sole shareholder would suffice, and Rolfe and Rolfe, where Mr Justice Newey, I hadn't appreciated it was my lord, that said that it's desirable that the decisions of a company should be objectively verifiable, and your lordship found that a mere fact that the shareholder had taken an internal decision that it was okay was not enough to ratify. It had to be communicated somehow. we say that is the right legal principle.
For what it's worth, on this particular occasion, my recollection is that something I've said has been confirmed by higher authority, namely the Court of Appeal in a case called Schofield. Whether the Court of Appeal approved this particular point, I don't remember, but they did generally approve of Rolfe and Rolfe. So it may be worth
We will check.
checking to see what Schofield said.
Yes. I mean, it may be the Court of Appeal didn't need. Oh, yes, I will check.
It may be they didn't need to approve that particular bit, but they approved something.
Yes. But in any event, we submit it's obviously right. It would be pretty unappealing if corporate action, the validity of corporate action depended on entirely unexpressed and unrecorded internal thinking, partly because if companies change hands, no one would have any idea what the position was. My learned friend has referred to one authority he says is to the contrary, which is Re Bailey. Very quickly look at that. That's Authorities Bundle 1, tab 19, page 348. And the question was whether particular shareholders had ratified a resolution to wind up a company. And you can see Mr Justice Brightman starting the first full paragraph. What these corporations did and did not do after 9th December, their affidavits in defence, points to one conclusion only. The conclusion is that they, and I emphasise these words, outwardly accepted the resolution to wind up as decisively as if they had positively voted. If corporators attend a meeting without protest, stand by without protest while their fellow members purport to pass a resolution, permit all persons concerned to act for years on the basis that the resolution was duly passed, and rule their own conduct on the basis that it's an established fact, it's idle for them to contend they didn't assent to the purported resolution. Now, that is no authority for the proposition that a company that simply does nothing is never asked or given the opportunity to express a view on the transaction, but simply does absolutely nothing, as was the case for Galliard Homes here, has ratified. To the contrary, there was a positive finding that there was an outward acceptance by attending at the meeting and not taking any objection to it.
Can I just ask a question which is a bit like the one I asked earlier, to do with the fact that the shares were going to be investors?
Yes.
Because it might be thought there's something odd anyway about the whole idea of ratification here, where there was already an arrangement under which there were going to be new shareholders.
Well, indeed, in part because, of course, one would have expected the directors of Galliard Homes acting honestly and properly to take into consideration the fact that there were existing obligations towards the investors. And so, although I don't think I can say that they were not capable of ratifying, it's a situation where one would expect the board of that company to think extremely carefully before they were willing to approve something which was highly prejudicial to a group of investors. But I don't think I can say it prevents them ratifying, because they are at the time the sole shareholder.
Anyway, it's probably not a pleaded issue. Probably wasn't an issue in the case, but I just do wonder whether it works legally. Because there are other cases where you can't ratify, for example, if the company,
For the creditors.
if the company is of doubtful solvency. And the reason for that is that someone else has an interest. And it could be argued on, anyway, sorry.
Yes.
It's not an issue in this case, it seems.
I will check. I don't think it was put that way below. But in any event, what it seems to me to do is to fortify the point that it is extremely difficult to attribute to Galliard Homes the intention to ratify where they haven't considered the matter, because there are obviously competing interests. And one would have thought that those three independent accountants, if they'd been told what was going on, given that they have duties, professional duties to act ethically and so on, would have said, well, we can't do this without legal advice as to what's the proper position. And it's no answer for Mr Conway just to say, oh, well, I'd have ridden roughshod over them and told them not to comply with their duties to give it independent consideration.
So you wouldn't put it as high as to say it couldn't be ratified, but you would say that when considering whether to ratify, it's important to have in mind all relevant context.
Yes.
And relevant context was that this was a vehicle which was intended to be transferred over to investors.
Yes. And indeed, certainly when one thinks about informed, I mean, ratification requires either knowledge of the circumstances one's ratifying or a reckless indifference or an indifference to what is being ratified. And Galliard Homes can't have ratified, therefore, without its board, its decision makers, knowing what had been done, what its consequences were, and what impact it would have on relevant stakeholders. But in some ways, I don't need to go so far as to say can't ratify, because I simply say this is the clearest possible case of there not being a ratification. Just Galliard Homes is just left out of it. They just do nothing. Finally, excusal under section 1157. Again, I'll just turn it up so you've seen it, although I'm sure you're all very familiar with it. It's Authorities Bundle 1, tab 6, page 46. Paragraph 1157, sub 1, enables the court, where a person is liable, to, if they've acted honestly and reasonably, and having regard to all the circumstances of the case, that person ought fairly to be excused, to relieve that person either in whole, in part, and on such terms as the court sees fit. Now, I would say this is a classic situation for the first instance determination, because this is not a discretion, but it's clearly an evaluative power. This is not a hard-edged point of law. We have to accept, of course, on the judge's findings that Mr Conway acted honestly. We suggest, however, he did not act reasonably, because the judge has found he knew that South Bank had a contractual right to the annex. And even if he thought that in some non-legal sense that was wrong, it's not what he intended to do in 2004, that does not mean that he is entitled simply to give it up for no value at all. The problem, as I say, is he started from the wrong starting point, qua director of South Bank. His position as director of South Bank shouldn't have been, I want to give up this interest if I possibly can. It should have been, I want to secure the best outcome for South Bank that I can. And that conduct was not reasonable for a director of South Bank. Nor does it make it reasonable that his lawyer did not stop him. Again, the problem is that he's looking at the wrong end of the telescope. The question isn't, was he legally prohibited from doing this? South Bank was entitled to someone who decided commercially, was it in the best interests of South Bank? Even if it was something that could legally be done, was it the right thing for it to do? So we say he didn't act reasonably. And we also say he ought not fairly to be excused. And first and most importantly, we say that he should not be excused where that would enable him to retain him and his family to retain the profit of his wrong. It's one thing to say you excuse a director who reasonably committed a breach and has caused loss and himself would end up worse off if he had to indemnify the company. It's quite another to say that he should be permitted to retain the benefit of his wrong, both historic and in the future. Now, I doubt there's any dispute as to the law here. The authorities say that the fact that the director has come off with property belonging to the company is not an absolute bar to excusal, but it is said to make it improbable that relief will be granted, and it's said to be a powerful factor against relief. And if those propositions are disputed, I can deal with it in reply, but I accept it is not a bar to relief, but I say it is a very powerful factor against, and in this particular case, there is absolutely no reason why Mr. Conway should be permitted to enrich himself and his family at the expense of the investors, particularly where it is now known that there was never a legal basis for rectification. And so whatever mistake Mr. Conway had got into his head, it was not a legally relevant mistake, and so this should never have happened. Similarly, particularly powerful case not to grant relief, where if such relief is granted, Mr. Conway and his family will continue to benefit to the tune of hundreds of thousands of pounds a year for the foreseeable future. The other fact that I rely on as a reason why he ought fairly not to be excused is the fact that by his own admission, he concealed this scheme from the investors in order to prevent them objecting. Now, I accept the judge found that that wasn't because he knew it was wrongful. It was just, as the judge put it, a hard-nosed commercial decision. But it's obviously an important factor in deciding whether he ought fairly to be excused. The director who acts transparently, engages with his stakeholders, and nonetheless makes a mistake can perhaps be excused the mistake. A director who specifically avoids telling the people his actions are going to affect in order to avoid them having any chance to object and put him right, takes the risk of where he ends up. And the court should not condone the conduct of directors who treat their investors in this way. So for all those reasons, we invite you to find that Mr. Conway either was in breach of fiduciary duty, not ratified and not to be excused, or at the very least conclude that we have a strongly arguable case to that effect, and it needs to go back to the judge for determination. That then takes me to what may be regarded as perhaps the most technical aspect of the appeal, which is the execution of the lease and the underlease. And so that's grounds 3 and 4, which I will deal with now before turning to grounds, before we turn to ground 2. So, starting point, lease and underlease are not validly executed. That is the judge's finding. He finds section 44 requires execution by a director signing. Director did not in fact sign because he instructed, Mr. Conway instructed his secretary or PA to sign in his name. We, as a consequence of the invalid execution, sought 2 things. The first is effectively declaratory relief, that the lease and underlease are void. And secondly, we seek rectification of the register by removing the lease from the freehold title and by closing both the lease and the underlease titles. My learned friend Skeleton says in paragraph 38 that rectification was concerned only with the lease, but that is just as a matter of fact wrong. We specifically sought rectification by closing the underlease. The judge's conclusion was that despite the invalid execution, the documents are to be treated as validly executed under section 44 sub 5. And just so my lord and my lady have seen that, it's authorities 1, tab 6, page 43. And what you have in subsections 44.1 to 44.4 are what is required by way of execution of documents, and the relevant form of execution here was 44.2b, or purported execution, signature by a director in the presence of a witness who attests the signature. That's what didn't happen. And then 44.5 is a deeming provision. In favour of a purchaser, a document is deemed to have been duly executed if it purports to be signed in accordance with subsection 2, and you have the definition of purchaser over the page. Is a purchaser in good faith for valuable consideration and includes a lessee, mortgagee, or other person who for valuable consideration acquires an interest in property. And two starting points to make about that section. First, it only applies in favour of a purchaser. And second, the protection is linked to the form of execution authorised by section 44. So it only protects a person where the document purports to be signed in accordance with section 2. This is not some general protection for good faith purchasers who believe, in some general sense, that the document has been lawfully executed. This is about documents which appear to have been executed in accordance with a particular legal regime. So starting with ground 3, this only concerns the underlease, and this is concerned with the words in favour of a purchaser. And the argument simply runs as follows. The deeming provision only applies in favour of a purchaser, and Lodgeshine was not a purchaser of the underlease because it was not the lessee or a person who acquired a valuable interest in property. It was in fact the vendor, so the seller, not the purchaser. And the judge concluded, if we just go back to judgment, core bundle, tab 6, page 146, the judge started, we say, from the correct position. Paragraph 416, he says section 44.5 applies to purchasers acquiring interests in property. And then he says there's a thus, we can ignore that sentence. Final sentence, similarly, Lodgeshine is not a purchaser from South Bank, and so section 45 does not engage a deeming provision that operates in Lodgeshine's favour to the effect that the underlease was duly executed. So far we submit so good. Judge has found that it does not, Lodgeshine does not engage the deeming provision that treats the underlease as duly executed. We say that's really should have been the beginning and end of the point, that South Bank was not invoking the deeming provision. It was positively bringing a claim seeking a declaration of invalidity and rectification of the register. And it was Lodgeshine who was relying on the deeming provision by way of defence of those claims. And since it cannot rely on the deeming provision in its favour, it was not entitled to rely on that to defeat the claims being made against it. Otherwise, we submit the deeming provision isn't operating in favour of the purchaser, it is being used as a sword against them. The judge, however, concluded that Lodgeshine could, it might be said, reflectively get the benefit of the deeming provision, and that is in paragraph 430. the judge refers to what we said in our written closing submissions, that it only applies in favour of a purchaser. Underlease is not in favour of South Bank since it's trying to be released. Judge says that because we didn't say that in our oral closings, he proceeds on the basis not being strenuously pursued. Well, it wasn't any view being pursued strenuously or otherwise. And he then explains why he disagrees with it. He says, in any event, in my judgment, section 44.5 is capable of applying in favour of South Bank. Well, that is true. South Bank is the purchaser. Clearly, there's been a change in the management of South Bank since the date of the underlease, equally true. However, at the time of the underlease, South Bank was under different management, which positively sought registration of the underlease as a legal interest in land in reliance on the proposition that it had been validly executed as a deed. Now, where we struggle with that is why that makes any difference whatsoever to section 44.5. He doesn't explain how that transmutes section 44.5 such that it can be relied upon in favour of Lodgeshine. True it is that at the time of the underlease, different management, without reference to section 44.5, regarded the document as validly executed and so registered it. Of course, our entire rectification claim is on the premise that that was a mistaken view of the validity of the underlease. We are saying it shouldn't have been registered because people at the time were proceeding on the basis that it was validly executed, but in fact it wasn't validly executed. And it is therefore rather circular to say that by registering, we are prevented from asserting that the register was mistaken because it did not reflect the true legal position. And I should make it clear, there is absolutely no suggestion that South Bank relied on section 44.5 at the time of registering the underlease, simply submitted it, no doubt because Mr Conway believed it to be validly executed. So this isn't a case where South Bank is blowing hot and cold as to whether it's going to rely on the deeming provision. Now, there may well be arguments, could have been arguments, that the registration of the underlease is an estoppel by representation. But that is not how the case was ever put. And no doubt that would have suffered the difficulty that it would have needed Mr Conway to say that he'd relied on his own representation, which might have been regarded as a rather unworldly conclusion. But on any view, the judge's reasoning here about a company being under previous management and previously treating a document as valid gives absolutely no basis for inverting section 44.5, so it applies in favour of the seller instead of in favour of the purchaser. Equally, my own friend advances what is either the same or a variant of that argument in his skeleton argument, paragraph 40.1. He says, section 45 doesn't contain a presumption or a provision we can rely on at our election. It's a deeming provision, given their ordinary and natural meaning. And then he says this, so in favour of a purchaser, a document is deemed to have been validly executed, means that where the relevant circumstances apply, the document is contrary to reality deemed by statute to have been duly executed by a company. In this case, the circumstances did apply. Now, the problem with that is it simply reads out of the statute the words in favour of a purchaser. I mean, that's simply saying where a document appears to have been executed in a particular way, all parties, it will be treated as against all parties as having been validly executed. And so, yes, we agree it's to be given, the words of the statute to be given their ordinary and natural meaning, but the ordinary and natural meaning is that the deeming provision can only operate in favour of one of the parties, the purchaser, and if that party therefore wants to rely on the truth, it is not bound to accept the deemed provision to the contrary, notwithstanding that it is harmful to its own interests. And there's nothing unfair about that. Doesn't, as my learned friend suggests, make this a charter to escape from a bad bargain. It just reflects the fact that we are dealing with a situation which is ex hypothesi, the contract is in fact not validly executed, and the purchaser could walk away from, and a legislative decision has been taken that therefore only the purchaser should be able to benefit from the fiction that the contract was in fact validly executed. Now, there are all sorts of other doctrines that might be relied on to protect the seller in that situation: estoppel by representation, estoppel by convention, waiver, election, but not section 44.5. And we say there is simply no coherent basis to read the words in favour of the purchaser out of the statute. And therefore there is no basis on which we can be forced to treat the contract as valid in circumstances where we regard that as disadvantageous and we wish to rely on the true legal position.
So just pausing there, that's really the end of ground 3, is
It
it?
is.
Ground 3 of itself would get rid of the underlease but not the lease.
Yes.
So part of your hotel you would have no right to use.
Yes.
But that's something that you would go for if it were a choice between everything being valid and everything, and this you'd prefer to knock out the underlease alone.
Yes.
Yeah.
That then leaves ground 4, which is the good faith provision, the good faith part of the ground. And so this applies to both the lease and the underlease, and indeed it must apply equally to both of them, because Mr. Conway's knowledge and therefore the company's knowledge is the same in each case. And the way the judge approached this, if I can just again turn to the judgment, core bundle, tab 6, page 147. It's paragraph 421. So he says, I consider that my factual findings in paragraph 396 dispose of the arguments on an absence of good faith. I'll turn to that in a moment. Mr. Conway genuinely believed both the lease and the underlease had been validly executed. This was demonstrated by the fact that he caused all the companies to be treated as bound by those documents and procured that they acted accordingly. And paragraph 396 is back on page 142. And the gist of what's said there is that he didn't know what was legally required, didn't know that asking Ms. Akers to sign documents in his name was not a valid form of execution. And at the end of the paragraph, I infer that Mr. Conway genuinely thought the lease and underlease were validly executed. So the judge's approach is, provided he believes that what he did was legally valid, he's acting in good faith. Now, we submit that the judge could not reach that conclusion and that a person cannot, or a company cannot be treated as acting in good faith for the purposes of section 44.5 if they know of the very fact which renders the execution of the documents invalid, and indeed knows that they have not been executed as a matter of fact in the manner described in section 44. And so we say that where Mr. Conway knew that they have not been signed by a director, he cannot rely on a provision which deems a document which appears to have been signed by a director to be valid. Now, just to make clear what the judge found as to fact, as to what Mr. Conway knew, as I say, the problem with the execution here was that the documents were not signed by a director. They were signed by his, I think, PA or secretary. And obviously, one might say it's self-evident that Mr. Conway knew the documents hadn't been signed by a director because he's the sole director and he knows he hasn't signed them, so he knows they haven't been signed by a director. But in fact, the judge made specific findings about what happened, and those are on page 141. Paragraph 391. Mr. Conway did not himself sign either of the lease or the underlease. Instead, he asked Ms. Akers, that's his secretary, to sign his name for him by writing the S. Conway signature on both documents. Mr. Akers duly did so. And in paragraph 392, he says, second sentence, I infer Ms. Akers followed that general practice and did not sign the lease or underlease on her own initiative, but sought and obtained Mr. Conway's specific instructions to do so, probably following an oral discussion between them. So Mr. Conway knows, beyond a shadow of a doubt, that there is going to be a simulated signature on these documents, and he knows that they will not be signed, in fact, by a director. So we are not challenging the judge's fact findings. We positively aver Mr. Conway's knowledge as found by the judge, nor is this a challenge to any evaluative decision by him. It is a more fundamental question about what is meant by good faith in section 44.5, and in particular, are we right that one cannot be acting in good faith where there is actual knowledge of the fact which makes the execution defective? And we say that that is the position, that actual knowledge of the fact which makes the execution defective is inconsistent with good faith for three primary reasons. First, we suggest that the purpose of section 44.5 is fundamentally to protect a purchaser who is provided with a document which appears to be signed in a manner which would be lawful, so two authorised signatories, director in the presence of a witness. And the purpose of section 44 is to allow that person to assume that the document was executed in the manner it appears to have been without having to investigate whether that appearance is true. And so, for instance, it's not necessary to go and investigate whether the director had been validly appointed. It doesn't matter if actually the person purportedly signing as a director had never been validly appointed. Wouldn't matter if the witness hadn't in fact seen the signature being witnessed, but appears to have done so on the face of the document. But there is no obvious purpose to be served in protecting a purchaser who knows, actually knows, without inquiry, that the document is not executed in the manner required by section 44. Such a person doesn't deserve the protection of being entitled to assume that the document has been executed in the manner which it purports on its face to be executed, because he or she knows it hasn't been executed in that way. And we say section 44.5 should be construed by reference to that purpose. It should permit a person who genuinely doesn't know otherwise to assume that a document was executed as it purports to have been executed. But it should not...
Sorry, I'm sorry, I interrupted you. You were just halfway through a sentence. I thought you were at the end.
No, I was going to say it shouldn't be interpreted to permit a person who knows that a document hasn't been executed or knows it's been executed in a different way to treat the document as though, contrary to the reality, it had been executed in the manner provided in section 44.
If this had, in this case, with the unusual way that the document was executed or purportedly executed, if the purchaser had been some complete third party, do you say that that protection would have been available? So even though it's been done in this way with Miss Akers, in fact, inserting Mr. Conway's name,
Yes. So if the
it could have been some completely arm's length purchaser, would this protection apply?
So if that purchaser, so let's say Southbank was under the control of the investors at the time.
Yeah.
If that person had no idea, they got the document, it said S. Conway on it, and they had no idea that it'd been signed by anyone else, they would be protected because they wouldn't know the fact that renders the execution invalid. But if they'd been sitting in the room when Ms. Akers signed the name S. Conway, and so they knew the document was not what it purported to be, no, they wouldn't be protected. And frankly, why should they be? Because they're not relying on the document being executed as it purports to be executed. They're just taking the risk that they knew it had been executed in a different way. And the second point we say is that it would reward people who made misleading documents. So let's say this document had been executed by Ms. Akers signing, as was in fact the true position. She signed Ms. Akers, PP, S. Conway. Now in that circumstance, section 44.5 wouldn't apply. Doesn't matter how much everyone believed that was valid execution, it wouldn't attract section 44.5 because the document did not purport to be executed as required by section 44. Wouldn't have purported to be signed by a director. Now, why should the person who creates a misleading document and knows that the document is in that sense misleading, be in a better position than a person where the document actually reflects what happened? It wouldn't help if this had been signed by Ms. Akers, PP, Mr. Conway. It wouldn't help him one jot to say, well, I genuinely believed that my secretary could sign it on my behalf. I genuinely thought that was valid execution. I gave her authority, it's all fine. Section 44.5 wouldn't be engaged at all because it simply didn't purport to be executed, signed by a director. Why should Mr. Conway be in a better position where the document is simply ex facie misleading? Third, we submit, section 45 is essentially a statutory version of the equitable principle of bona fide purchaser for value. And it is well established, we submit, in the context of that doctrine, that the essence of good faith is a genuine and honest absence of notice of the relevant matter. So, for instance, if you're a bona fide purchaser of a property that's subject to some competing interest, you need to show that you did not have notice of the competing interest. And we've referred in our skeleton to Midland Bank, and I'll just show your lordship, your ladyship, that's Authorities Bundle 1, tab 20, page 42. Seems like a bad reference. Page 365.
£365.
365.
Thank you.
And It's really from paragraph D. My lords, the character in law known as the bona fide good faith purchaser for value without notice was a creation of equity. In order to effect a purchase of a value of a legal estate with some equity or equitable interest, equity fashioned upon his conscience and the composite expression was used to epitomise the circumstances in which equity would or rather would not do so. I think that it would generally be true to say that the words in good faith related to the existence of notice. Equity, in other words, required not only absence of notice, but genuine and honest absence of notice. And then he goes on to say, but it actually extended further. But that essence of the absence of notice, we say, is very much should be used to interpret the statutory version of the bona fide purchaser.
But might that be said to suggest a different test? Because you can have notice where you don't know. Whereas you're saying it turns on whether you knew.
So I would say, yes, actually, the proper interpretation here would be if Mr. Conway would need to show he had a genuine and honest absence of notice of the problem with execution. But certainly, if there is actual knowledge, on any view, there's notice.
And I see the way you put it, but take your purchaser, the ordinary purchaser, the third-party purchaser, who sees Mr. Conway's signature. As it happens, has had a letter from Mr. Conway on which he's seen an alternative signature, but doesn't connect the two. Might that purchaser be said to be on notice of something being wrong?
So ultimately, I think that is a question of fact and degree. If, for instance, he saw the signatures were different, realised they were different, and didn't ask any questions, I would say he's on notice. Something funny seems to be going on, and there's a decision not to check. Equally, if that purchaser knows it is Mr. Conway's practice to ask his secretary to sign documents, and he decides not to check who signed this particular one, I would say he's on notice. And again, my submission would be that person is not a good faith purchaser. They are choosing to run the risk. They know there is a potential problem, and they are choosing to run the risk, and they are not deserving of protection. But I would certainly say that on any view, and I appreciate this is dodging the question because you have to draw the line, you have to say what the test is, but on any view, it can't be good faith where you actually know, not simply suspicion, not a question of avoiding inquiry, you actually know the true position. You are absolutely not deserving of a presumption that something has been done in a particular way where you know it has not been done in that way. And so we submit that the judge was wrong in principle to say, well, if he was acting in the abstract in good faith, he's an honest man, and he didn't realise there was a problem with execution, that's enough. We say that was the wrong way of, that was an incorrect reading of what good faith means, read in the context of section 44(5), and therefore none of the companies are purchasers as defined because they weren't acting in good faith.
And just to be clear, I know that a comparable formula is to be found in section 74 of the Law of Property Act, and I think you probably find a comparable formula elsewhere as well. But no one's found any authority explaining what good faith means in such alternative contexts.
I certainly haven't, and I don't think my learned friend has.
Yeah.
It's a fairly unusual situation, I think it's fair to say. It's rare that a signatory will be, or a party will be trying to rely on a signature that, in a sense, it knows the true circumstances about. Usually the cases are more about the transaction as a whole looks suspicious, and therefore should you be on notice that perhaps it wasn't really being signed by the person who appears to have signed it. Just dealing very briefly then with the consequences, if we are right, we say we would be entitled to the declaratory relief we seek, that the contracts were not validly executed as deeds and therefore do not create any estates in law. And we also say that we should be given an order for rectification of the register by removing the lease. Let me start that again. If the underlease is invalid, then its title should be deleted from the register. And I'll just, so in the transcript, that the title entry for the underlease is TGL 310894. If the lease is invalid, then its entry should be deleted from the register. That's TGL 310871. And also the reference to the lease on the freehold should be deleted. So it won't be a legal lease encumbering the freehold any longer. Now, Malone and friends oppose that, oppose the rectification on the basis that they say it's not permissible under the Land Registration Act. Can I, I'm sure you want to see it. It's Authorities 1, tab 5, at page 35. The way this works, under paragraph 2.1, the court may make an order for alteration of the register for the purposes of A, correcting a mistake. And I understand it to be common ground that if you conclude that these were not validly executed deeds, then it will follow that they didn't create interest at law. And if they didn't create interest at law, it is a mistake for the land registry to have created legal titles. So we are potentially in 2.1a. Now the starting point under paragraph 3, subparagraph 3, is that if the court has the power to make an order, i.e. there has been a mistake, it must do so, unless there are exceptional circumstances which justify it not doing so. And there is no suggestion here that there are exceptional circumstances. So the question is simply, does the court have the power to order rectification? And that turns on paragraph 3, subparagraph 2. If the alteration affects the title of the proprietor of a registered estate in land, no order may be made under paragraph 2 without the proprietor's consent in relation to land in his possession, unless A, he has by fraud or lack of proper care caused or substantially contributed to the mistake. Now, as regards the underlease, paragraph 3.2 has no relevance because the proprietor of the leasehold title is Southbank, and Southbank consents to rectification. As regards the lease, Lodgeshine there is the registered proprietor, so I accept that paragraph 3.2 is potentially engaged, but there are two reasons why it doesn't apply. First, the land is not in his possession, is not in Lodgeshine's possession, and one knows that because it's been underleased to Southbank, and therefore exclusive possession has been yielded to Southbank. That being the essence of a lease. Secondly, and in any event, we would fall within 3.2a, the mistake has been...
Sorry, I'm so sorry. Could you make that point again? Sorry.
Sorry. So 3.2 provides that there can only be rectification, an order for rectification cannot be made in relation to land in his possession, so in the registered proprietor's possession. So the question is the annex land in Lodgeshine's possession? If it isn't, this paragraph doesn't get engaged at all. And in our submission, Lodgeshine is not in possession of the annex, and indeed cannot be in possession of the annex because it has underleased it, and the essence of an underlease is that you have to yield exclusive possession to the tenant. otherwise it's a licence.
But does possession, where you've got a chain of leases, work in that way? Could it be possession as against the
In my submission, there's no reason.
proprietor, freehold proprietor here?
In my submission, there is no reason to read possession as anything other than, I would submit, its natural reading, i.e., the person who actually is in possession of the land, because they're bound to be a registered proprietor, so they're always going to be able to say, well, I have rights as against the person up the chain, because by definition, that the registered proprietor will always have rights because they are the registered proprietor. So the possession must be doing something more than that. It must be adding on some requirement.
Can you seek an order for rectification in relation to the lease where it's between two parties who don't want the register rectified?
Well, we're now the legal freehold owner, so it encumbers our title. So South Bank has now taken by virtue of the transfer under the freehold sales contract. So we are the registered proprietor of the freehold title.
Yeah, sorry.
The correct answer to your question is I don't know, but it doesn't, I think,
Doesn't matter
arise.
here.
In any event, we would say whatever the position on possession, Lodgeshine did substantially contribute to the mistake by its lack of proper care, because Mr Conway, the director, instructed his solicitor to simulate his signature, and a director acting with proper care, which is obviously an objective test, doesn't get a person to forge their signature. I shouldn't use forge. Shouldn't get someone to simulate their signature on a formal legal deed. And a person who chooses to do that and create documents that are not what they appear to be has contributed to the problem coming about. So we say absolutely no reason why we cannot get rectification.
This isn't something that the judge went into at all, was it?
Because he concluded that they were valid, he didn't go on to deal
We
with
haven't got any findings at all on these
Okay.
points. Right.
That then leaves me just the respondents' grounds to deal with, and it's all respondents' ground 3, but it's actually divided into 2 parts. Part 1 is estoppel by grant, and part 2, actual lease, if I can put it that way. So, the judge rejected the arguments based on estoppel by grant. That is in Core Bundle tab 6, page 142.
Sorry, which page?
142. 142. And he deals with this paragraph 397, which it really just sets out the relief that we are seeking, and then 398 and 399 deal with the estoppel points, and it said that my learned friend took what's described as a preliminary point. It's not open to South Bank to make these arguments against Lodgeshine because it is inconsistent with the first principle of the law of estoppel, as applied to relations between landlord and tenant, that a tenant is estopped from disputing the title of his landlord. And then the judge says at paragraph 399 that it seems to him that that rule does not apply to any of the heads of relief that we are, or any of the arguments we were making, largely because they don't relate to our freehold interest and don't engage the estoppel. or in Roman 3, that we are not challenging Lodgeshine's title, and so that doesn't fall within the relevant estoppel. And again, the judge says it might have engaged a different type of estoppel, presumably estoppel by representation, but that is not the estoppel on which Galliard relies. Now, in our submission, the judge was right to reject the argument that estoppel by grant has any relevance here. One general reason and two specific reasons. The first and the general reason, which might be said to be rather fundamental, is that estoppel by grant arises from the grant. And if the very question is whether there was a grant, because the question is whether the lease was in fact executed, you can't rely on estoppel by grant, because otherwise you are pulling yourself up by your bootstraps. It can't be credibly said, we would suggest, that the underlease, the existence of the underlease, prevents us from disputing the validity of the underlease when the question is, in fact, whether the underlease exists at all. And indeed, it would wholly undermine the statutory requirement that a disposition of a legal estate has to be done by deed, and indeed that a deed has to be executed in a particular way, if a landlord and tenant were stopped from arguing that a document, howsoever executed, validly disposed of a legal interest in land. It would completely undermine a statute that said you've got to do that by deed. So we suggest that this is simply not a world in which estoppel by grant can apply, because you don't get there until you have in fact decided whether there was a grant. And since the question in our case is about execution, we're simply not in a world where the estoppel can even arise. And there is no case, which I found, I don't think my learned friend has found any, where any person has successfully raised estoppel by grant in answer to a question whether a document has been validly executed as a deed. There are, of course, cases where documents executed as deeds have been found to take effect in equity, and one might have thought that if my learned friend's point was a good one, actually they've all missed the point, and they shouldn't have been arguing they took effect in equity. They should have been arguing you're stopped from denying that they had the effect that they purported to have. But it simply isn't, we say, a world in which estoppel by grant applies. Two specific reasons. As regard the underlease, we are not disputing Lodgeshine's title at all. And that's really the point the judge made at paragraph 399, Roman 3. Our challenge to the underlease doesn't depend in the slightest upon whether Lodgeshine does or doesn't have its own title to the annex. And indeed, it certainly won't damage any interest that Lodgeshine has in the annex. If we are right that the underlease is invalid, Lodgeshine will have whatever interest it has under the lease. And so we are not attacking its interest in any way. And I'm afraid my learned friend puts it in paragraph 60 of his skeleton. At the very bottom of the page, as to the second strand, Southbank's argument that it's not bound by the terms of the underlease was in terms a challenge to Lodgeshine's reversionary interest. Now, I'm afraid I just don't understand what that means. Attacking the underlease does not challenge Lodgeshine's reversionary interest at all. If anything, it's likely to enlarge that reversionary interest because it will revert earlier. So it is certainly not a challenge to Lodgeshine's reversionary interest. Finally, as regards the lease specifically, that we submit does not engage any estoppel, because South Bank is simply asserting its own pre-existing freehold title, which was the point the judge made in paragraph 399 Roman 1. It is simply saying that even before this lease happened, it had a beneficial interest in the freehold, and it is still has an interest in the freehold, and it would like to assert that, and it says it is not encumbered by the lease.
I mean, you are denying the validity of a grant which your predecessor purported to enter into.
We are. We are. That is absolutely right, and that is the way my learned friend now puts the argument. It was not how it was put for the judge, but it is put in paragraph 60, however, that the tenant can't dispute, sorry, that the grantor can't dispute the validity of the grant, and that we are we are stopped by the assignment, effectively. We say that doesn't apply. Obviously, we say it doesn't apply because this is a question of execution, and you're not into estoppel by grant, where the question is whether there was a grant at all. But leaving that aside, we say this simply isn't within the scope of the principle, essentially because the principle of estoppel by grant only prevents the lessor saying that it had no legal title to the property at the time of the grant. And one sees that that's how the estoppel is identified in Woodfall, Authorities Bundle 4, tab 56, at page 1674. Under the heading estoppel of lessor, it deals with two different types of estoppel. Estoppel where there's a recital as to the interest, we don't need to worry about that. But then about 2/3 of the way down the paragraph, it said the second is estoppel by grant, which will apply where there is no representation of title. In such a case, the landlord will be estopped only from denying that he had no title at all. It appears that if he had some title, the estoppel will not apply and the tenant will acquire a legal estate not exceeding that of the landlord. So that, we say, is the true limit of the principle of estoppel by grant. All that South Bank is prevented from doing is saying that it did not have a legal title, or that the lessor did not have a legal title at the time that the lease was entered into. And this is not a principle which prevents it saying that the document was not validly executed, or there was some other defect in some other legal defect in the grant.
So just talking around it for a moment, suppose that this were not our situation, but Mr. Conway had caused a company he controlled to grant a lease to a third party. And that the lease, there wasn't valid execution. Now, potentially the third party would be saved by section 44.5, I suppose.
Yes.
Supposing the third party wasn't saved by section 44.5, say because they knew of the practice of getting mistakers to sign in Mr. Conway's name, it would then be open to Mr. Conway's company to deny the validity of the document that it had entered into.
Yes. And we say estoppel by grant really just isn't concerned with that situation. You may have section 44.5, you may have estoppel by representation. Outside section 44.5, the authorities deal with a situation where a document appears to be witnessed, but isn't, but by handing over a document that appears to be witnessed, you represent that it is. and if the other party relies on it, you're stopped from denying that it wasn't witnessed. But estoppel by grant is really, we suggest, a much narrower principle as it applies to the lessor, which is simply to stop the lessor saying, my deed is invalid because I, in fact, never had any title to grant to you. And it is true, it has sometimes been expressed in broader terms. My learned friend relies on the First National Bank case, which is Authorities Bundle 2, tab 26. Page 237.
Page, I'm sorry.
Sorry, 497.
Thank you.
Oh, it's my fault, I gave the internal. About 3 lines down, it's talking about estoppel by grant. It says the other is more widely based. It's not a species of estoppel by representation and does not depend upon the presence of any recital or other express representation of title. It's a product of the fundamental principle of the common law, which precludes a grantor from disputing the validity of or effect of his own grant. It's exclusively the creation of common law, not equity. And my own friend relies on that and said, well, no, this is a very general principle that stops you relying on the validity or effect of your own grant. But actually, if you look to the, that is obviously being said in the context of representations about title. And if one goes down even on this page, for example, to F, it says the common rule that a mortgagor cannot dispute the title of his mortgagee was recognised in a particular case. Neither depends on what's been called a technical doctrine of estoppel, which is representation, but on the refusal of the common law to permit the grantor of a legal estate to deny that he had legal title. And I just pause to say, well, if it's read as some much broader doctrine that prevents any challenge to the validity or effect of a lease, what is the position where somebody enters into a document that is entitled lease, but actually on the reading of its terms is a license? So that's your classic case where Street and Mountford, House of Lords have said, well, if you are not in fact giving up exclusive possession, irrespective of what label you put on it, it is still a license. Is it being said, well, you purported to grant a lease and therefore you're stopped from saying it's a lease? Where does the ambit of this doctrine lie? Is it really being said that if any document that purports to be a lease has to be given legal effect as a lease, irrespective of whatever legal defects it has, even if it's not a lease on its own terms? So what is the ambit of the principle? If my learned friend is saying it's broader, we say it is essentially a principle trying to deal with title, which is of course why you get into the context feeding the estoppel.
Can I just talk around another scenario?
Yes.
So now we have a company granting a lease to a company controlled by Mr. Conway.
Yes.
Mr. Conway, in accordance with his normal practice, has Miss Akers sign, and the lessor knows nothing about that, but then discovers. Now, the lessor, potentially, subject to the arguments we're going to hear, at least on your case, can't invoke Section 44(5).
Yes.
Well, I suppose I'm now in a scenario where the lessor wants to get rid of the
Yes.
lease anyway. So is it open to the lessor to say, look, say be it I purported to grant you a lease, but actually you, the lessee, didn't execute it properly, and so it's an invalid document?
So my answer to that is yes, subject to genuine estoppel. So by genuine estoppel, I mean if the company could say, well, company which wanted to benefit from the lease could say, I didn't know of any problem with the execution. That would be different. But obviously, if the company does know the problem with execution, it's simply run the risk, and it shouldn't be able to say, well, just because this is a lease, I should be able to treat it as valid. And again, can I just pose it as a rhetorical question? What are the limits of that doctrine? Let's say the document doesn't purport to be signed at all, but it says it's leased between two companies and one hands it over to the other. Does the estoppel by grant apply in that situation? Purports to be a lease, hasn't been validly executed, hasn't been executed at all. But what then, if valid execution is not the dividing line, what is the point at which this estoppel by grant stops you denying that what is not a lease is in fact a lease?
And just talking about it a bit more, as I think you're saying, there are cases out there where there have been disputes about estoppel of a more conventional kind in relation to the validity of documents.
Yes. Yes. And one of the cases I think one of us refer to is a classic case of estoppel by representation, where it was being said that where a document appears to be witnessed, you can have an estoppel by representation that it has been witnessed, unless the person receiving it knows it has not been witnessed, because then they by definition can't rely on the representation. So yes, it's not, section 44.5 doesn't cover the ground. There may be other situations, including situations where a party later treats it as valid and then can't turn around and say, oh, well, bad luck, I've changed my mind. And that would be classic election between inconsistent remedies. You can choose to treat it as valid or invalid. You can't do both. But for better or worse, that's not the way the case was put below by the respondents. So for final point, just on estoppel by grant, we do suggest there's an oddity in this idea that we're the assignee. Prior to the legal interest being transferred, we had an equitable interest which we could assert against third parties. And if the agreement had only taken, if the agreement between hotels and Lodgeshine had only taken effect as an equitable lease because it wasn't validly executed as a deed, we would have been entitled to say, well, our equitable interest is first in time. So our equitable interest takes priority. And we wouldn't have been bound by any estoppel because we weren't the assignee of anything at that stage. Why are we in a worse position given that we have taken the legal estate and therefore the burden of the legal lease subsequent to our equitable interest arising? Why are we now prevented from asserting our pre-existing interest in the annex, which we had before the lease was even granted? We say that can't be a correct analysis. Otherwise, you've effectively reversed the equitable order of priorities, which means, subject to notice, first in time gets priority. So in our submission, estoppel really just isn't, estoppel by grant really just isn't the right way of dealing with the situation that happened here. That leaves me with the last point I've got to deal with, which is equitable leases, and will not take me, I hope, very long at all. The respondent's argument is that even if I'm right on everything I've said to you so far, they still have equitable leases. And I, of course, have to accept that a contract that isn't validly executed as a deed can still take effect as a simple contract, and if it's specifically enforceable, will give rise to an equitable interest. And of course, this, again, it turns on whether the contract is specifically enforceable, because that is what creates the equitable interest in land. And of course, I should just say if the lease is not valid in equity, then obviously the underlease can't be valid in equity, because via Latin's not helpful, nemo dat quod non habet. If Lodgeshine wasn't itself an equitable lessee, it couldn't grant an equitable estate itself. Now, we submit that neither the lease nor the underlease would be specifically enforceable given the circumstances in which they were concluded, namely Mr Conway's lack of clean hands because he was in breach of fiduciary duty, or because the lease was entered into in breach of trust, which may come to much the same thing. It may be a specific example of a lack of clean hands. Now, given that this overlaps with the questions of breach of fiduciary duty, we again suggested that if you get to this point, it's a question that's better sent back to the judge. But let me just explain why I say these leases would not be specifically enforceable, and therefore my learned friend is wrong to say that they get any equitable, create any equitable estates. The first, clean hands. Obviously, what we say is that the Annex Lease Scheme was a set of transactions which were all undertaken by Mr Conway in breach of his fiduciary duties, and in very large part for his own personal benefit. And if we are right about that, we say that equity would not lend its aid to a wrongdoer by ordering specific performance, so as to enable the wrongdoer, Mr Conway and Lodgeshine, to secure the benefit of a breach of equitable duties. Equity is not going to assist someone to breach equitable principles or their equitable duties. It's not going to assist them to take the profit of their own breach of their own equitable duties. We say that is a classic case of the clean hands doctrine. We've referred, obviously there are many cases on clean hands, but we've referred to UBS and Leipzig. That's Authorities 3, tab 43, page 1108. Bottom of the page, paragraph 170.
I'm sorry, I'm slightly behind you.
No,
Just
I'm
give
sorry.
me a moment. It's okay. Yes.
Paragraph 170. So this is dealing with the question of whether a party could obtain rescission, but generally discussing availability of equitable relief. And it is said, Judge directed himself by reference to the passage of Lord Justice Aikins in RBS and Highland Financial Partners. That was, I think, a anti-suit case, so seeking an injunction. And I think it was being said that false evidence had been given in support of the application, and therefore should not be granted equitable relief. And at paragraph 158, I think the quote, no dispute there exists in English law a defence to a claim for equitable relief, which is based on the concept encapsulated in the actual maxim, he who comes into equity with must come with clean hands. And then at paragraph 159, it's common ground that the application of that is limited. To paraphrase Lord Chief Baronet in Durling and Earl of Winchelsea, the misconduct or impropriety of the claimant must have an immediate and necessary relation to the equity sued for. And that is then applied in paragraph 171 of this case, where the judge says that the key part of it is that the misconduct or impropriety of the claimant must have an immediate and necessary relation to the equity sued for, and that it must also and it must be shown that the claimant is seeking to derive advantage from his dishonest conduct in so direct a manner that it is considered unjust to grant him relief. Now, just pausing there, the reference to dishonest conduct comes from Spry. It's quoted around letter E on that page. But obviously, although that is, Spry has expressed the required link by reference to dishonest conduct, there is no principle that clean hands is simply another limited to dishonesty. It is, as is referred to in the other quote, any kind of misconduct or impropriety may suffice if it has the necessary relation to the equity sued for. And the point then made is this is one of those multifactorial assessments with which an appellate court will be slow to intervene. So essentially, unsurprisingly for an equitable doctrine, multifactorial assessment, is it just, or would it be unjust to grant a person relief in equity because of their own misconduct or impropriety linked to the relief they are seeking? We say that principle must apply here. There is an extremely close link between the misconduct, namely granting a lease in breach of fiduciary duty, and the equity sued for, which is giving effect to the lease granted in breach of fiduciary duty. It is the closest possible link. It is trying to get the benefit of the very contract which was the product of the wrongdoing. And we say in those circumstances, equity is not going to come to the assistance of Mr Conway and his company Lodgeshine to enforce leases that he only granted, or were only granted in circumstances where he was in breach of his own duties. As to the second principle, breach of trust, it is expressed to be a general principle that a court will not enforce a contract made in breach of trust. One can take that from Snell. It's Authorities Bundle 4, tab 57, at page 1679. Sidelined passage.
Just want to have to, for the purposes of your argument, you have to assume that it's quite a difficult thought experiment, this, because one's imagining a case being brought, put all of these two leases in place,
yeah,
but by people who aren't saying to the court what we're doing is a breach of duty, because they are all on the same side of that. In fact, it's Mr Conway, so he's not going to pop up to say, by the way, I'm doing this in breach of duty.
I suppose two answers to that. One, maybe it depends when you ask the question. It's only if you're asking the question come trial, the counterparts to each of the leases, the lease and the underlease, are under independent control because it's South Bank. And so they very much would be popping up and saying, we do not want you to specifically enforce this contract. Because the lease is South Bank to Lodgeshine and the underlease is Lodgeshine back to South Bank. So if you imagine a situation where this came up at any point after the rent guarantees expired, undoubtedly South Bank would say, I don't want you to specifically enforce those contracts. And I would say that's the right time to judge it, because of course the cases or the textbooks suggest the equitable interest is defeasible if specific performance would not be granted. And so certainly by the time the rent-free period ends and the investors take over South Bank, they are going to be saying don't specifically enforce this contract, and whatever may have been the position for the 5 years where they're all in common control, there can't be any continuing equitable interests after that because specific performance would be granted. But yes, secondly, I think I would accept, or I would argue as a more general proposition, that it can't be an answer for the wrongdoer to say, well, I wouldn't choose to raise the point in opposition to an action for specific performance. I think the court has to posit the thought experiment, assuming all matters were put before it, would it have granted specific performance of the lease? Otherwise, one can't know whether an equitable interest would arise, because it would depend on the happenstance of who controlled a company from time to time.
Can I just see if I'm uniquely disadvantaged? You referred to the sidelined passage.
Yes.
I do not have any sidelining anywhere in my authorities bundle.
Me neither. Mhm.
Ah. Well, I have a very neatly sidelined bundle, which I appreciate is no help to you whatsoever.
So where are we?
Do you want to have a further set of authorities that are sidelined, or is it now too late?
I think it's too late.
Late.
I can only apologise because I know the juniors on both sides worked very hard. Indeed, there was an immense amount of cooperation in a way there sometimes isn't to agree which authorities you actually needed and which were uncontroversial and to sideline them. And I don't understand how it is that...
I mean, it may be that if we checked the online version, we would find that that's sidelined. I don't know.
Yes.
I'm afraid I haven't at the moment checked the online version.
But where are we on page
Sorry,
1679?
second paragraph,
Thank
beginning
you.
where a trustee,
Yeah.
it's the final sentence, equally, where trustees make a contract in breach of trust, a court will not grant specific performance of the contract. And that's a reference, as the footnote reveals, to some fairly old cases. Paragraph 1, footnote 142 over the page, Turner and Harvey from 1821 and Dunn and Flood from 1885. I think it's fair to say that I would urge you to conclude analytically that is probably a clean hands principle rather than necessarily any independent principle. But the point is still a good one. Here, Galliard Hotels holds the property subject to the trust created by the FSC. The entire, or one of the key purposes of that trust is to require it not to harm the property that is going to be conveyed, including by leasing it beyond its own interest, and Lodgeshine should not be permitted to take advantage of that breach of trust, which it was necessarily aware, given that Mr Conway's knowledge is attributed to all of the companies, by granting specific performance of a transaction which was in breach of the trust designed to protect that interest. And so we would say that you should conclude that neither the lease nor the underlease took effect in equity, or in any event, you should conclude that that may well be the case if we're right about breach of fiduciary duty and therefore it needs to go back to the judge. I should say, I don't think you need to reach any conclusions about what the effects of that would be, but obviously we say it would be very significant, because if the lease and underlease neither take effect in equity nor in law, then South Bank will simply be able to say, well, we have absolute freehold title, there are no proprietary interests affecting the annex, so thank you very much, we will occupy it without paying anyone anything. And it may well be that that results in some subsequent claim, but on its face, as a matter of proprietary interest, if there are no legal or equitable estates encumbering the freehold, we would be in the very happy position that we would have, at least going forward, the freehold to enjoy. Whether that would affect the claim for arrears of rent for so long as the underlease was in place is a different question, but certainly going forward, we would have the unencumbered freehold title.
You've referred there and elsewhere to a situation in which the matter would have to go back to the judge, you say. If we got to that point, would it be this judge or a different judge on your case?
Well, I think it has to be this judge. I mean, I think if I were to say to you, it wouldn't be appropriate for this judge to deal with it, then I ought to be asking you, your lordships, to deal with it, because
otherwise you have a complete retrial.
You're in the same position otherwise, yes. Or we have a complete retrial, which seems to me not the appropriate way forward. And I don't have a basis to suggest that, given guidance as to how the task should be approached, the judge would not approach it in a fair-minded way.
Yeah. Now, it does come up to 4:15. I know Mr Porcaderi is going to deal with the other aspect.
Yes.
The other aspect itself, I think, is rather important, isn't it? I mean, were you to win on the other aspect, that might more or less achieve your aims.
I think I'm careful about what I say. I think legally yes, practically perhaps not, because it's not clear to us that Galliard Homes is a company of substance. So Galliard Hotels is a company of substance.
Yes, I see.
So a damages claim against the former freehold owner may not yield us very much. It might, but it's not clear to us it would.
Yes, I see. At any rate, it's now 4:15. Mr. Pocaderi would be entitled to half an hour in the morning before we got to the end of your rationed day. But if he thought there were a need or that it would be helpful, I think we could go on for another quarter of an hour now. Alternatively, he might prefer to take up the half hour in the morning and leave it at that.
Well, shall I sit down and let him speak for her?
Thank you, my lord. I'm entirely in your lord's and ladyship's hand as to how I proceed. I can do 15 minutes now and 15 minutes in the morning, or half an hour in the morning.
Let's put it this way. If you were confident that you would conclude your submissions within the half hour, I think we'd stop now. If, on the other hand, you think you could need more than half an hour, I think we ought to go on now.
If I assert that I'm confident and I end up going to 10:35, I'll be in trouble. So I think I'm best starting now.
Yes.
Thank you. As my learned friend Mr. Willen indicated, I'll be dealing with ground 2 of the appellant's grounds and ground 2 of the respondent's grounds. And these concern clause 9 of the room leases, which we say amounts to a continuing contractual obligation, which was breached day after day, causing us loss. And nearly every aspect of that is in dispute in this appeal. So there are 4 issues in play. The first is whether clause 9 of the room leases contains an obligation that might be the subject of a contractual claim at all. This is the first point the respondents make. Second, if so, is the obligation a continuing one or a once and for all obligation? Now, the judge found it was a continuing obligation, but again, the respondents say he was wrong to do so. Third, and this is our ground of appeal, assuming there was a continuing obligation, was Galliard's breach a continuing breach? And fourth, has there been a loss? So here the judge didn't make a determination as to loss. He mused that there may be no loss, and the respondents say there is indeed no loss. So,
And the second was, if it's a continuing obligation, is it a...
So the first is it a contractual?
Yes,
is it
yes.
a contractual? Second is it a continuing? Is it a continuing obligation? Third, was there a continuing breach?
Thank you.
Fourth, has there been loss?
Thank you.
And I'm going to deal with those in turn. But first, I'm going to go through the room lease itself. And that can be found in the supplemental bundle, tab 2. And page 9. And you can see on page 9 that it's a tripartite agreement. Galliard Hotels, the example of the room lease we have there is Mr. Crowley and Mr. Marley. So they're a pair of investors, and South Bank is the third party. And you can see their roles at page 12. Galliard Hotels is defined as the landlord. Mr. Crowley and Mr. Marley are defined as the tenant. And South Bank is the company. There was one of these room leases with each of the investors. This one was entered into on the 30th of January 2008. The judgment records that they were entered into with all the investors between January and July of that year. And so most of them were entered into before the Annex Lease Scheme. South Bank's role under this document can be seen at clause 8, and that's at page 21. so the tenant, that's the investors, appoints the company, South Bank, as its agent to act on its behalf and in its name to locate a permitted occupier to occupy the demised premises. So that's essentially finding a hotel guest to occupy the hotel rooms. And at clause 8e, South Bank is entitled but not obliged to appoint a hotel operator to carry out and perform its obligations. There's more detail on South Bank's obligations at Schedule 6, and that's page 36. Schedule 6, paragraph 1, imposes on South Bank a duty to hold the payments that hotel guests make as trustee for the investors. Importantly, clause 3 requires South Bank to find a hotel operator, but then under clause 4, if it's unable to do so, South Bank is required to perform the business, and the business is defined as the hotel business, and as set out in Schedule 7. So we then go to Schedule 7 at page 40. And Schedule 7 sets out various aspects of running the hotel. Under clause 6 here, the hotel operator shall, where reasonably appropriate, if you go over the page to 6F, provide such ancillary facilities and services as are reasonably appropriate. And at the bottom of that page, clause 14, the hotel operator shall use all reasonable endeavours to, and then there's another copy of that page, so you need to go 2 over. And from 14.2, you see that the obligation is to maintain the common parts. There was a dispute below as to whether the common parts comprise the annex or not, and the judge found that it did include the annex, and there's no appeal in respect of that finding. So with that background, we go to clause 9, which is at the heart of this case, and that's at page 22. The landlord hereby grants to the company the right to utilise the common parts in conjunction with its appointment by the tenant in clause 8 for the purpose for which they are properly intended. And it was common ground below that clause 9 did not permit or authorise a charge to be imposed in respect of that. So that's the room lease, and that brings us on to the first aspect of the respondents' grounds on this issue. And the respondents say that clause 9 contains nothing to which a contractual claim can attach. They say it's just a right over land. Now here, I'll address your lordships and your ladyship in 3 parts. First, there's a short answer to that contention. Then I will go to the respondent's reasoning and expose its flaws, before returning to invite the court to apply conventional principles to construing contracts to clause 9. So the short answer comprises 2 simple propositions and a conclusion. Proposition 1, if someone has a right, then another person has a corresponding duty. Proposition 2, clause 9 is a right contained in a lease, which is a type of contract. Conclusion, it's a contractual right, and Galliard have a corresponding contractual duty. Nice and easy. Next, I'd like to turn to the respondent submissions. They can be found at page 397 of the core bundle, or page 22 of their skeleton argument. In my submission, there's an oddity and incoherence in the reasoning in this part of their skeleton argument. So, paragraph 55, they say the judge erred in concluding that the room lease contained or included an obligation which might be the subject of a contractual claim. They then go on to say, on the contrary, clause 9 conferred on Southbank a right, whether contractual or proprietary, over land. In my submission, if they are saying that it conferred on Southbank a right, brackets, possibly contractual, then it necessarily imposed a contractual duty on Galliard, and there is a contractual claim. The respondents then go on to say, clause 9 was not a promise to grant Southbank a right to use the common path in the future. So it seems the respondents are saying that all Galliard needed to do was to permit Southbank to use the common parts for a scintilla in time, the second the lease was entered into, and then there was no remaining obligation whatsoever. In our submission, there's no basis in the language of the contract or commercial common sense to support such a contention. At paragraph 56 of the skeleton argument over the page, an analogy is drawn with the law of easements, and the respondents say that the grantor of an easement has no duty to maintain or repair the right of way, and so similarly here, clause 9 imposes no obligation on Galliard Hotels whatsoever, let alone a continuing obligation.
And in fact, you don't have to maintain it doesn't mean that you can obstruct it.
Precisely right. And that's the point that the judge found. But it goes further than that, and that's because it's established that in the context of a landlord, they do have a duty to prevent disturbances of the right of way. And we can see that in Woodfall. So volume 4 of the authorities bundle.
Sorry, just hang on.
Tab 57. Page 1677.
So page 1,
677.
that's
1677.
yeah, and that's going to be at 56 rather than 57, I think.
Ah.
That's why I was just
No,
querying.
you're sorry, forgive
Yeah.
me. Yes. you're
So
right.
A4 56 1677.
Yes.
Sorry.
Uh,
So Woodfall.
and I was going to invite the court to look at the sideline passage, but it's the paragraph right at the bottom.
So 11291.
Yes, maybe. And so this passage is about rights of way, and it's headed disturbance of right of way. An action on the covenant for quite enjoyment may be maintained for the disturbance of a right of way granted by the covenantor. And then it goes on to say, where, however, the landlord grants a right of way to a tenant, he may be under a duty to secure that the right of way remains unobstructed, and therefore may be liable for breach of covenant if he fails to take steps to prevent his other tenants from blocking the way. So there's the point that my Lord Justice Newey raised, but there's also the point that even if it is an easement, very often it's coupled with a contractual duty to leave the way unobstructed. And the judge agreed with that analysis at paragraph 377 of his judgment. I won't take the court to it now, but I commend that analysis to the court.
And now you're moving to a new point.
I'm going to just finish off
Oh, yes.
by saying that these analogies, again, aren't actually entirely helpful. And I would submit that the proper approach is for the court to simply look at the contractual words used in the context in which they are used. And these words say, Galliard Hotels has granted South Bank the right to utilise the common parts, which it needs to utilise in conjunction with its appointment to run the hotel. I'm paraphrasing. And the lease reflects a complex commercial scheme concerned with the running of the hotel, in which, amongst other things, South Bank is contractually obliged to do various things in relation to the common parts. And we say that it is consistent with that scheme for South Bank to have an enforceable right to use the common parts, and it's inconsistent with that scheme for South Bank not to have such an enforceable right. So now I finished that first point.
So I think it's as well you claimed your extra quarter of an hour.
Sorry, do you mind if I just
No,
ask a
please do.
question? Sorry, I'm just trying to get my head around where this point goes. Is this just of historical interest, this point?
In what sense, my lord?
Well, this is a lease entered into by a room lease entered into by Galliard Hotels. As freeholder,
Yes.
South Bank is now the freeholder.
Yes.
So this isn't binding on Lodgeshine if the lease is otherwise valid and effective, and that's subject to all the arguments we've been hearing.
Yes. So
The result is that Lodgeshine is the lessor under the long lease. South Bank is a freeholder. So how does this agreement now operate going into the future? That's to say, the room lease.
yes, my lord. So the first point to make on that is that for the historical period between the 25th of May 2009, which is 12 years before the claim was issued, and the date of the transfer, Galliard Hotels certainly was the freeholder, so they're liable to pay damages in that respect. The position thereafter, and the quantification of those losses, we say is a matter that should go back down to the judge. So as long as this court is satisfied that there is a loss for some of that period, the extent of that loss and how long it lasts is a matter for the judge below, I'd say.
But when I say it's only of historical interest, it's a claim for damages, effectively.
Yes,
And
yes.
it doesn't affect the position going forward from now.
No.
Right.
Precisely.
I see. Thank you.
So that leads me on to one point. There was a mention earlier of the possibility of a corporate structure, and if somebody could produce corporate structure, that would be very helpful.
We will do that, and I'll share it with my learned friend so you can have an agreed document. Can I say one thing very briefly? My Lord Justice Miles asked me about the meaning of in possession earlier, and I have taken the opportunity to look at that, and I was partly right and partly wrong. Section 131 of the Land Registration Act says a proprietor is in possession if it is physically in possession, so it is physical possession. But my lord was right that there is a deeming provision that a landlord is deemed to be in possession if a tenant is in possession. So that argument I have to withdraw.
Right.
So I have to rely on the lack of proper care. I can't rely on the not in possession point. I apologise for not having checked that soon.
In which case we'll stop now and start again at 10 o'clock in the morning.
All rise if able.